Good afternoon, everybody, and thank you very much for joining this International Travel Law Network conference. It's a year since we had our last one, and there's a lot to talk about. First of all, I should tell you that this is being recorded, and a copy of the recording will be sent out to people who've attended today afterwards. So we've got a range of speakers from across Europe who are going to tell us about developments over the last year in travel law. Many of those come still out of the pandemic and the consequences of the pandemic legally and the travel industry. But some don't, some are independent of that. We're going to look at, in brief, we're going to look at the connection between holiday cancellations and government advice, government travel advice. We're going to look at a recent Court of Justice case about price reductions and when they are payable. We're going to look at cancellation dates and when it is premature or not premature to cancel a holiday. We're going to look at financial security, what's happening in various countries about bonding, security, insurance, financial protection. We're going to look at some recent case law in various countries. We're going to look at the ongoing review of the Package Travel Directive by the European Commission. And we're going to look at the right of redress against suppliers, which package organisers have under the directive. So that's plenty to be going on with. The event is in the nature of discussion, which we have a nominated leader for the discussion who will start the discussion going, but then people are welcome to join in with the discussion, or you can use the chat function if you want to ask a question without speaking. Right, okay, so straight away onto the first subject, which is about the relationship between cancellation of holidays and government travel advice. And Michael Vukasic from Austria is going to lead this discussion. So over to you, Michael.
So thank you, Stephen, and good afternoon, everyone from Vienna. Basically, I have a case pending before the European Court of Justice, which is related to the issue of termination of a package and government travel advice. Before I shortly explain that case, I've been asked to give a brief overview on the termination rights under the Package Travel Directive related to unavoidable and extraordinary circumstances. So on the traveler's side, it is referred to in Article 12, paragraph 2, which basically says that the traveler can terminate the package in the event of unavoidable and extraordinary circumstances that are occurring at the destination or its immediate vicinity and are significantly affecting the performance of the package, or if they significantly affect the carriage of the passengers to the destination. I think that's an issue we will be talking about a bit later as well. On the organizer's side, we have a right to terminate the package of the organizer if that organizer is prevented from performing the services under the contract because of unavoidable and extraordinary circumstances, and notifies the traveler about that without undue delay before the start of the package. So that's basically the legal framework for the case I'm going to talk about. The case deals with a package that was booked by a medical practitioner in Austria in May 2020. So remember May 2020, that was after the first so-called lockdown, when everyone already knew about the COVID pandemic. And the package was for the Maldives for late December 2020 to January 2021. So on the 1st December, the Austrian government issued a travel warning for the Maldives, a travel warning of the highest level, warning from any travel to the Maldive Islands that is not necessary, and in particular, touristic travel, because of the COVID pandemic situation. Following that travel warning, the organizer decided to cancel the package. So here we have a situation in which there was the termination not by the traveler, but by the organizer because of the travel warning. As a consequence, the traveler filed a lawsuit, and he sued for loss of income for some days before the scheduled time of the package and for 2 days after the scheduled time of the package. And in addition to that, he sued for loss of holiday enjoyment, but the larger part was the loss of income. So in first instance, as well as in second instance, the claims were fully dismissed by the Austrian courts, because these courts held that as regards loss of income, there was no causal link between the cancellation and the loss of income, because had he gone to the Maldives Islands, obviously he would not have earned any income as well. And regarding the loss of holiday enjoyment, both instances held that the cancellation by the organizer was justified because of the travel warning issued by the Austrian government, because it would have been unreasonable for the organizer to still perform that package to a place where the government wants to go to. Anyway, the second court instance allowed a further appeal to the Austrian Supreme Court, and the Austrian Supreme Court referred the matter to the European Court of Justice. And basically, the Austrian Supreme Court filed two questions. Question number one, can the organizer refer to unavoidable and extraordinary circumstances in cases when the competent authority of the state of domicile of the traveler issues a travel warning of the highest level for the country of destination? And secondly, if that question is answered in the affirmative, then does it still apply if the traveler himself declares that he would still be willing to go there despite the warning by the government? That was one issue that was brought forward by the claimant. He said, I would not have minded the travel warning. I wanted to go there anyway. In our statement to the European Court of Justice, we tried to do some kind of balancing act, because we really do not want to regard any travel advice of a government as constituting unavoidable and extraordinary circumstances. So what we tried to argue was that in the particular situation, the uncertainty about the pandemic situation in the first pandemic year, 2020, at that time, it was reasonable for an organizer to cancel a package as soon as such a travel warning of the highest level was issued by the authorities. So apart from the two parties of the procedure, it was the Commission and it was Greece who filed written statements to the courts of justice. And the Commission argued that a travel warning or travel advice by the government is an important indication for unavoidable and extraordinary circumstances. So that's their proposal for the first question. And regarding the second question, they say that the organizer's right to terminate the contract does not depend on the traveler's willingness to still go there. And Greece, in their written statement, they were of the opinion that the travel warning itself would constitute unavoidable and extraordinary circumstances. And regarding the second question, they also agreed that the traveler's declaration to be willing to still go there does not change anything. So that's the situation so far. We don't have a date scheduled yet for an oral hearing. So let's see when that is going to happen. So I leave that open for the discussion now. So basically, is it the travel warning or the travel advice itself that constitutes unavoidable and extraordinary circumstances, or are such advices only indications for such circumstances, or do they not count at all?
Thank you very much. Thank you very much, Michael, for that very clear explanation. I think, Klaus, in Germany, you wanted to say a few words at this point, just about, only about the government advice and looking at it from the consumer side, as it were. Does it entitle the consumer to cancel a holiday if a government advises against all but essential travel?
Yeah, okay, thank you, Stephen. So based on the experiences of the last, I would say, 2 decades, we have always a situation that travel advice from the Foreign Office is an indication, and it's properly said from the jurisdiction as well as in the literature that this kind of indication is a very strong indication for allowing at least both sides, organizer as well as a traveler, to cancel his package travel contract. But due to more global travel and due to travelers coming from different EU community states or even from third-party countries, so that means that we have a number of foreign offices announcing their individual travel advices that might be partial advices, that might be advices just for a certain region or for the capital city, but not for the whole region. And for this, we have travelers becoming nervous due to looking into 1, 2, 3, 4 different foreign offices and getting different advices, and then coming back to the tour operator and say, hey guys, you say it is okay. The English one said, no way to go. And then we looked to the Swedish, and the Swedish said, yeah, you can go, but you should not go to that specific area. So what's true now? So from the German jurisdiction, it's pretty clear that once again, travel advices is an indication for on the one side the traveler, on the other side for the organizer, but there must be additional information sources, maybe the DMC, which is locally on the spot and can probably judge much better. And it's not due to the pandemic, but we have a number of catastrophes that might lead to a certain situation. If we talk about hurricanes, a hurricane might have been gone, but the destroyment of the hurricane can be judged. It would take at least 2 months to be clear again and to reopen a hotel, or it could take only a few weeks, for instance, so that depending on the gap between travel booking and departure of travel, there might be plenty of time to go back to normal. So that really depends on the individual case. And it is not the travel advice that is also not in the pandemic, purely judging this is extraordinary circumstances, and that leads to free of charge cancellation from the traveler side or allows the organizer to cancel. So that is an individual declaration of consent that each party gives, and if they feel they should go for a cancellation, they can, of course, but they have to give proof of evidences, and one indication for that is a travel advice, but not the only one.
Thank you very much, Klaus. That's very helpful. In the UK, I think the position is that if the government advises against all but essential travel, that is taken by the courts as very strong evidence. It's not conclusive, but it's very strong evidence of extraordinary circumstances and unavoidable extraordinary circumstances. And it would be very difficult, not impossible, but very difficult to prove the opposite to that. So I think that's the position here in the UK. So I throw it open. If anyone else has got a comment or question or experience on this subject, please feel free to unmute yourself and join in.
Stephen, hi, it's Bharat from ATO.
Hello, Bharat.
Hi, I'll stick my camera on so people can see my ugly mush. Just going back to the EUJ case that you're discussing there, can I ask, what we encountered here as tour operators is where the TA has changed to over essential travel, but the client wants to go. They've been able to. We saw that when Spain's travel advice due to the pandemic was changing, and when it went to red at one stage, people were allowed to travel. It was their responsibility to take the risk, and the tour operator's liability was arranged accordingly. With your case, particularly from Austria, were the flights going, and was the performance of the package deliverable?
Michael.
So basically, I think the decision was made in order to avoid liability.
Mm-hmm.
So the organizer didn't want the traveler to go there and then perhaps be infected with COVID and then getting back and suing for compensation because they did not observe the travel warning issued by the government. That I think was the main reason for their decision. Actually, there were still flights going to the Maldives, so there was no landing ban or anything like that. So the performance of the package services would have been possible, but the question remains, would it have been reasonable?
Okay. And what if a client or a passenger is willing to accept that risk and renege their right to liability or to blame the organizer? Will that stand up in court, I guess? If you have a clause in the contract that says, you know, I'm doing this on my own volition, I don't hold the responsibility to the tour operator or organizer if I get ill, for instance.
I think it would be quite hard for an organizer to refer to such a clause in the contract or in general conditions because of the Consumer Protection Act, which provides for a very high level of protection. And they probably would say, oh, well, the organizer always knows better than the consumer. So when the consumer signed that contract saying, oh, I know about the situation and am still willing to go, he didn't really know what would happen there. And so it's quite likely that such a clause would be regarded void.
And one last question, if I may, Stephen, associated with this. Would the airline refund the travel organizer because they're still flying, but the package has been cancelled? Because that's been a big issue in the UK.
Actually, I don't know about the situation between my client and the airline in this case. I don't know whether they were charged for those flights or whether they could cancel these flights without any costs. I don't know what happened there on this side. I'm only involved in the dispute between the traveler and the organizer.
Thank you.
Clara, you have your hand up. We'll make this the last question before we move on to the next subject.
Yes, I just wanted to make a comment because I really wanted to react to the proposal of the client to make a release that he would say, I'm accepting the risks, I want to go, because it is just a week when I was on the call with many colleagues who are involved in sports, lawyers who are specialized in sport activities in the mountains, and this is exactly the topic which we discussed, the topic of releases and where it is and it's not possible to waive liability. And it was very interesting to hear, because it's colleagues from all around the world. And there was a big distinction between the colleagues who are from codified Europe, continental Europe, and from the colleagues who are from the common law world. So probably if, but unfortunately, package travel directive is mostly the continental world, right? And in the continental world, the answer was in 99.9% of cases that this kind of release would not be possible, because even if you accept the risk, you simply cannot release you cannot do that. The law doesn't allow that, especially or only in some exceptional circumstances. So whenever there is your health, your personal injury at stake, you cannot do it. Whereas in the common law world, for example, in South Africa, in Australia, New Zealand, in the United States, it was very free. So we were told that in this case the release would work.
Can I also remind everyone that the Package Travel Directive and in the UK our package travel regulations have a specific provision saying that consumers cannot be deprived of their rights under the Package Travel Directive. So that creates a further problem for the suggestion. Ian Taylor, I said that Clara's was the last question, but I'll allow you to sneak in if it's a fairly short one.
Yeah, it's very quick, but and it's not really the point at all, but I'm curious why the traveller has pursued this to the extent they have, especially a medical practitioner, given the time, when when the virus was still a real threat and so on, and the variants weren't fully understood, and we didn't have the vaccines, the vaccination programs hadn't been rolled out at that point. So it's curious, and I wonder if the traveller was coming at this for political reasons more than individual ruination of enjoyment, because they had I don't know, some position on COVID and the restrictions. But also I'm curious why the appeal court needs these rulings from the European Court of Justice, because the law seems reasonably clear, doesn't it? So I wondered if, Michael, you've got a take on any of that.
Okay, so first remark to your first question, Jan. I don't think that there is any political background. I think it's just the fact that the plaintiff has legal insurance, so he doesn't have to care for the costs. Whatever the proceedings cost, he will be compensated by the insurer. So he just takes the risk, or he hasn't got the risk in this way. So what he gets, he will get. And if he doesn't get anything, it will not cost him anything. So that's the big problem that we have in package travel law cases in Austria all the times, that sometimes really ridiculous lawsuits are filed just because the claimant has insurance coverage for that proceedings. And sorry, now I forgot the second question.
Well, I was just curious why
Yeah.
that you've gone to the Court of Appeal and then been referred to the Court of Justice for a ruling?
Yeah, so basically, the second court instance, the High Regional Court in Graz held that there is no Supreme Court decision under the new package travel law that implemented the new directive, and therefore it was a case that should be decided by the Supreme Court. And the Supreme Court said, oh, well, that's all new to us as well, and therefore we prefer to get clarification by the European Court of Justice.
Thanks. Okay, well, thank you. That was a great discussion. We must move on to another subject now, and we're going to talk about a recent Court of Justice case which has been decided about price reductions involving the German and indeed Europe-wide company FTI Touristic. Clara, I think you're leading us on this.
Yes, thank you, Stephen, and hello, everyone. We are bringing now to the stage the FTI Touristic case number 396/21. If someone hasn't heard yet, but I believe that everyone here has already heard about this case, this German case, which unfortunately got to the ECJ. We are talking about this case because I believe that during the COVID times, I think that most of us are representing tour operators. So I think that most of us were trying to find different ways of interpretation in order to favor the tour operators. And hence we will probably also looking for different interpretations to favor the tour operators in situations when there were different COVID restrictions placed in the destinations. And I have to say that at the time, I found very helpful German case law of lower German courts. And this case law was referring to the restrictions, to COVID restrictions imposed by the government as to the normal risk to life situations. The German lower courts were basically saying that if a government places restrictions, for example, that you can't go to the beach, you cannot use swimming pools in such a great number of people, then this is a normal risk to life, and the situation is not covered by the strict liability of the tour operator. Hence, the client does not qualify to a discount. And the German courts were saying only in the situation when these restrictions would lead to the fact that the recreational function of the package would be destroyed. In this case, of course, yes, this would be too much. And I have to say that we liked this in our office. We liked this interpretation given by lower German courts. So we prepared many answers to the claims of consumers in this sense, and we were quite happily living with that for a couple of years, actually. But
Clara,
then, unfortunately,
Clara, can I just interrupt? I failed. For those who don't know you, I should have said Clara is based in Prague in the Czech Republic. Apologies for not saying that.
Sorry, I didn't prepare personal promotion. So we were happily living with that, but then unfortunately FTI, probably based on this case law, rejected a claim of one couple who went to Canary Island in March of 2020, and their tour was really affected by restrictions. After 2 days of their package, they basically had to stay at the hotel. Several of their services were eliminated, and at the end, the package really was finished earlier, and they left the Canary Islands earlier. But they received zero compensation from the FTI, which led them to pass a claim to the court, and court finally eventually asked the ECJ for preliminary ruling. And unfortunately, the court was not thinking in favor of tour operators at all. It took the text, and I would say the text and nothing but text of the Article 14 of the PTD for granted, and gave no chance to the FTI and hence tour operators. But this is the time when I will stop, because we have a person here from my office, Renata Králova. You will see her in her box as Klára Dvořáková, but it's not me, it's Renata. And Renata is here because she, when the Court of Justice was hearing this case, she was representing the Czech Republic at the hearing. She was part of the team which was preparing the argumentation. And believe it or not, Czech Republic was, I think, the only who was trying to fight for the fact that tour operators should be, I would say, respected, and maybe at least there should be some, the reduction shouldn't be so high. Renata, how was it? Did the tour operators have some chance in the eyes of the ECJ, or was it lost from the very beginning?
Okay, good afternoon, everyone. Thank you, Klára. Actually, how was it? We came to the court. We were realistic. We did not hope that the court would dismiss the consumer from the price reduction. But we were actually hoping. We were hoping that maybe they would take into a consideration that PTD directive is a directive which is based on the Treaty on the Functioning on Article 169. So it's about not only a consumer protection, but the internal market as well. So we were hoping that the court would give such a clue or recommendation how the national courts to judge these cases. And we had the oral hearing in June, and then later on there was opinion of Advocate General Medina delivered on the 15th of September, and she said that the price reduction must be appropriate, taking into account all the circumstances in the case, which is a matter for the national court to determine. So we still had a little hope. Maybe the court would use the special methods of interpretation, which is called theological reduction. For those who don't know about this method, it was created by the president of the court, Professor Kim Leonard, who says, as a matter of fact, the court may depart from the wording of EU law provision where it considers that a textualist approach would excessively broaden the scope of that provision, thereby giving the rise to unfair situations. And we were asking the court, is it fair to kind of punish the organizer for obeying the law? The organizers of package tours, they were complying with the laws that were implemented in order to fight the virus. So the organizer had nothing else to do but to comply with the law. But we finished with the ruling that it's not including these special circumstances of the pandemic, because it says it must be assessed in the light of the services included, the reduction, in the package concerned, and must correspond to the value of the services for which a lack of conformity has been found. So not even this mentioning the special circumstances, as Advocate General said, should be taken into consideration by the court, but unfortunately the court ruled according to with the literal interpretation, taking very little from the theological interpretation, and finished like you said. So this is about it.
Thank you very much, Renata. Thank you. And
Maybe
yes,
Stephen, before we give the floor to ask questions to Renata, I would add the input, the final input with the consequences, and then we can discuss broadly. After the judgment came, we were analyzing because, as I mentioned, we recommended to many tour operators to reject their claims. To reject the claims of the consumers. So after FTI, we were thinking, okay, what is going to happen next? What should we advise to our tour operators now? And at least according to Czech law, we came to the conclusion that in the situations where the tour operators drafted signed agreements, settlement agreements with their clients, so these situations were, in our opinion, fine. At least under Czech law, this judgment cannot retroactively break the agreements. But on the other hand, in the situations where no agreement was signed and the tour operators only rejected the clients, then of course, at least under Czech law, clients have 2 or 3 years to ask for the compensation or to claim it at the court. And then, of course, the third advice, which we then provided to our tour operators, was, okay, now we have to treat the situation differently. And whoever of you implemented into your general terms a provision, which was based on the previous case law of lower German courts, it has to go out immediately. So that happened. And I already see Klaus raising his hand, and I think, Klaus, the floor is yours, because my question, and I have a question for you, because of course it's the case law came from Germany. So my question is how German courts and tour operators are now reacting to the situation, and whether you believe that there is some possibility that this case law of normal risk of life, that it can stand, at least that it can survive, at least with respect to some situations.
Thanks, Clara, for the question. So firsthand, let me contribute a little bit to the FTI case, where I would say it is no surprise for most of us, and I would assume it's also no surprise for my Austrian friend Michael, what has happened at the European High Court, because since decades, it's pretty clear that we might like it or not. That is another question. But basically, we have, as you said, also a strict liability of the tour operator regarding the essentials and the content of the package travel. And here we go back to the package travel contract, and the contract means all the items beginning from the hotel with all its amenities and all the other structure will be namely part as essentials of the package travel contract. And that is on the one side. That is what the consumer has concluded with FTI. And then he's going to travel to Gran Canaria. And then he sees on the spot that some of his typical essentials of his package travel contract are not working. And that is a deviation from what he has concluded. And with that deviation, very simple, and that is since decades, German case law, and not only German case law, but mostly European case law, we have with this deviation, the liability for reimbursement of travel fare on the side of the package travel organizer. And that has nothing, but really nothing to do with the risk of life. It's simple, a comparison between the contracted issues and the issues what the traveler finds at Gran Canaria. And with this deviation, the reimbursement is pretty clear. When it then comes to add-on liability, for example, loss of holiday enjoyment, things like that, there you have to have an explicit liability of the tour operator. And of course, during the pandemic, there is no explicit liability of the tour operator. So an add-on damage or penalty couldn't be the fact here. But for the basic travel contract, that is what we have since 20 years. And we have a very nice essay from a colleague of all of us named Holger Hopperdietzel, who has very nicely explained that this is standard since 20 years and no surprise at all.
Thank you very much, Klaus. So, and of course, this case doesn't just relate to COVID situations, it relates to any extraordinary circumstances which may affect a holiday. And it shows that consumers are entitled not to, as Klaus has just said, not to loss of enjoyment and those things, but to a price rebate for parts of the holiday which were not supplied, even where it is what in the UK we still often call force majeure situation, or unavoidable and extraordinary circumstances. Anyone want to come in, ask a question or say something about this subject? Please feel free. If not, we will move on to the next subject. Okay, right. Well, the next subject.
Michael has raised hand.
Sorry?
Michael has his hand up.
Oh, right.
Just a brief remark from the Austrian perspective. I could see at least one positive aspect in the FDI judgment. Some voices in Austrian package travel literature, in particular from the consumer association side, of course, they were of the opinion that a failure of the traveler to communicate a lack of conformity at the spot, to tell the organizer about what's going wrong, has no impact on the right to price reduction. And in that judgment, in the FDI judgment, the court explicitly said that such a failure has to be taken into regard when assessing the price reduction. So it does have an impact whether the traveler communicates the lack of conformity or fails to do so. And that's a positive aspect from Austrian industry perspective.
Thank you, Michael. For the UK people who are on this conference call, just a reminder, if anyone's forgotten, that although the European Court of Justice is no longer, of course, binding on the courts in the UK, the views expressed by the Court of Justice will have a very strong influence on our judges, particularly when they're considering a piece of legislation like the package travel regulations, which are basically European law still, despite Brexit. Right, the next subject we're going to talk about is the cancellation dates. When is it too early for a consumer to exercise his or her right to cancel a package holiday? And does it make a difference whether after the date when the consumer cancelled, the package organizer, the tour operator, actually had to cancel the trip anyway? So this is a subject on which Klaus is going to lead, and then I've got a few words to say on it after as well. So Klaus, please.
Thanks, Stephen. So yeah, the question regarding the cancellation date is one that is also actually at the European High Court, and we will have a decision hopefully this year or in the beginning of next year to that question. Let me say something that is adding to the question of cancellation dates first, to put that in a context. So it is very depending on the question, is it a booking that is done prior to the knowledge of Corona, or is it a booking that took place in a month where all of us could know about the Corona pandemic and the situation? So if the Corona pandemic known at time of contract conclusion, it's a different story. And to make it quite short, is if so, then free of charge cancellation is over. So that is a result of it. So if you know that you are booking with certain possible developments due to the pandemic, you accept as a customer that there will be probably situations you should or you could have foreseen. And with the foreseeability of that, the question of extraordinary circumstances is gone and it's over. So basically the EU law assumes that the corona pandemic occurs in the time window after the conclusion of the contract and before the start of the journey. So if the pandemic has already started when the trip was booked, this exceptional circumstance cannot be taken into account for a free cancellation. In this case, however, the second requirement of a significant impairment is at that time no longer relevant. And that makes a decisive factor for foreseeability of the pandemic already at the time of booking. And if you know at time of choosing the trip, then the agreed compensation means cancellation fee has to be paid as a normal case. What you can say, basically, there is no need to protect the traveler in this situation. And the second rule that comes out of that is if there is an objective knowledge of the pandemic, then it's not the individual corona measures that are taken from the regional governments, from the government at all, from certain authorities that are decisive, because it's the objective knowledge in the back of the pandemic that gives the lead in this story. So taking that into the account, coming to the question cancellation dates, when are they too early for the consumer, for the organizer? So for the organizer, it's quite simple to answer. Every cancellation is too early because we want people to travel, of course. And but the basic legal question that is coming up with a cancellation date is if you have a cancellation date that is, let's say 6, 9, 12 months prior to the departure date, how could you really judge as a consumer? It's the same for the organizer, no one can, but let's take it from the perspective of the consumer. Who can really judge from that day, 6 months, 9 months, 12 months in advance, what will happen to the pandemic situation? And even more, knowing that the pandemic situation is not a linear one, but explosive one on the one side, but also going down in the same way. So what we have is sinus, cosinus waves like this in the development of the pandemic. So who can judge what really happened at the destination? And that makes it very difficult. So the German jurisdiction has developed in the past a rule saying you must do a prognosis on whether there are extraordinary circumstances that will influence heavily your performance of your planned holiday and your planned travel. And if there is a 20% to 25% realistic prognosis that there will be risks of life or similar or at least situations where you can expect that the travel organizer is not able to perform the package in the concluded way, then the 20 to 25% prognosis level will be enough to allow a cost of free cancellation, even if it is in a time frame that is above that 4 to 6 weeks. So from a literature point of view, we have a statement that says 4 to 6 weeks will be the period where some reasonable prognosis can be given. What is beyond that 4 to 6 weeks, there will be a prognosis that is so-so. Honestly, we have a lot of jurisdictions saying even if there is a cancellation 3, 4, 5, 6 months in advance, and the prognosis is done by the consumer, and the consumer is afraid to travel. And then we have pandemic figures in Italy, in Turkey, wherever, that are definitely too high. And even if they are compared with his point of origin, so his home destination, is higher at that time, even then, courts will say, no, that is fine. He can do that because we say no one can really know how the pandemic will develop. That means we have a 50-50 chance that it is critical. And with 50-50, we are far above of the 20 to 25% that need to be taken into account to give him option of free cancellation at that time. And then we came to the situation that we have the follow-up situation. There is a cancellation of the customer, and then we have the trip, and the trip is then canceled by the operator later on. That might be 4 weeks later, 2 days later, or 12 months later. So by canceling the tour later on by the organizer, 60% of the German, or let's say 70% for the time being, of the German jurisdiction is saying, so if that happens, we have no damage to the tour operator, so he is not allowed to call for his compensation according to the cancellation situation. And that means he can wait at least after receiving the cancellation note from the consumer side and wait what will happen, whether he is going to perform or not the original booked tour. And if the tour is canceled, then there will be no need to go for cancellation fees. And they even say if there is a reference to the payback of the travel contract, of the travel fare of the travel contract within 14 days, there is no need to correlate that with a CAX fee. So, but that is a normal practice of each tour operator. If you pay back by having a cancellation of a consumer, you will always go ahead and reduce the reimbursement of the travel fare by the relevant cancellation fee according to your schedule that you have implemented in your terms and conditions. So that is a normal way a tour operator will act. But the court is definitely saying, and up to the German Fed court is saying, no, we take a position that it is a so-called ex post perspective. We take into consideration what happens at the time of departure, the planned time of departure. And if you go, okay, then you can go also for cancellation fee. If you are not going, then forget about cancellation fee. So that is the easy answer. This is from our point of view, and we have a case at the German Fed court and waiting for a final decision of the European High Court in this case. From our perspective, this is pure nonsense because it is a so-called ex ante perspective that is irrelevant. At time of cancellation note, you have to do the prognosis, and that is exactly the day where we have to judge, is the prognosis correct or not correct? And waiting for what will happen later on is far off the basic package travel contract and has nothing to do with the basic contract anymore. And it is not fair to call from the tour operator that he has to wait at least up to 6-9 months before he can decide for cancellation fees or not, because when you receive that cancellation note, that must be the correct date. But once again, it is a time frame that could be excessive, up to 12 months or even more. When you talk about cruises or world cruises, you have pre-bookings at least 24 months in advance. And if you receive a cancellation, then who can judge what happens in 24 months? So from my point of view, definitely it's not fair to the tour operator to say you have to wait. And if you go, okay, then it's your cancellation fee. And if you are not going, then forget about it. So besides the fact that cancellation fees are difficult at all for the time being, So 4 to 6 weeks, that is the answer, will be a fair prognosis option, and everyone could see or could foresee what will happen at the destination, in most cases at least, and that will be the time frame where you can properly judge what's going on. And if it's longer than that to time of departure, forget about. But once again, 70% of German jurisdictions said, oh no, we don't tell, we don't care, we allow the customer to cancel, and that is German consumer jurisdiction, and we don't like it very much.
Thank you very much. Thank you very much, Klaus. I want to add something about what's been happening in the UK on that subject. So until about 2 weeks ago, we had a test which was called the Flicker of Hope test, and the cancellation was said not to be justified if there remained a flicker of hope that the tour could go ahead. This resulted in the date being much closer to the departure date in the UK, on which a judgment is made, probably a matter of days or 1 or 2 weeks at most, rather than the 4 to 6 weeks you're talking about, Klaus. And indeed, you're saying that the German courts allow much more time than that. Well, so a very different approach in the UK. However, the law has been changed in the UK about 2 weeks ago by a case in our High Court called Sherman against Reader Offers, in which the court decided that Flicker of Hope test was too favourable to the travel industry, and they recast the wording as whether there was a reasonable possibility of the trip going ahead. Now, it sounds like a easier test for the consumer to say, oh, there wasn't a reasonable possibility, rather than there wasn't even a flicker of hope. In practice, what difference it will make remains to be seen. The case on where this was decided was not a COVID case. It was a case involving a cruise in the Northwest Passage in Canada, and the question of whether ice was going to melt sufficiently quickly to enable the cruise to take place. And of course, things, well, I say of course, the expert evidence was that the things can change very quickly. If you get the right wind and the right temperatures and so on, it can go from a bad situation to a good one very quickly. And so these questions of flicker of hope or reasonable possibility became very relevant. And anyway, the High Court decided that the correct test is a reasonable possibility. I still think that'll be a shorter time than 4 to 6 weeks in the UK, that you can make a judgment whether a trip can go ahead or not. Right, so anyone want to, Clara, I think you said you'd had a recent case in your Supreme Court on this point.
Well, if we still have time, yeah, I just wrote it to our chat. But I think we are pretty in line with what has already been said. We don't have a specific timing. So the Supreme Court, yes, so in the Czech Republic, this question got to the highest court, to the Supreme Court of the Czech Republic, and the court didn't say 1 week, 2 weeks, 3 weeks, 1 month. Even though I believe that the court was also influenced by German case law, because in Czech Republic we simply like spying on German courts. The countries are very close in terms of jurisdictions, and so the court must have known about this 4 to 6 week framework. And I think it's even mentioned in the text of the judgment. But then the final text simply says that it has to be assessed on a case by case basis. But what I think is important is the fact that the court is rejecting the idea that it would that, for example, there would be some reassessment of the situation, because the court says the consumer can wait. We can ask the consumer to wait until this moment when it is visible, when we can objectively assess the situation, because it is well, the consumer of course has a right to withdraw anytime, but only in the time when it is already, when the situation can be assessed, his right then can be connected to the free cancellation.
Thank you very much. Anyone want to come in on this subject of the consumer right to cancel and get a full refund without suffering cancellation charges?
I have a short remark regarding the issue, what happens if the consumer terminates and then at a later date, the organizer has to cancel the trip. So from my point of view, as soon as the consumer terminates the contract is gone. So there is nothing that the organizer can cancel. So you might say, if it's a cruise, well, the cruise ship didn't left the harbor, so there was no trip. But what about a flight and a hotel for a certain time of period, and no one else booked a similar package? So what should the organizer perform as soon as the consumer terminated the contract? So I think that's a really wrong test to look what happened afterwards. The package is gone as soon as the contract is terminated by the organizer. So what happens later on should not be relevant at all.
Thank you, Michael. I saw quite a few heads nodding in agreement with you about that. So if you're fighting cases, whichever country you are in, if you're fighting cases on this point, remember what Michael said there and fight on that basis. Okay, is there anybody else in the audience want to come in on that subject before we move to the next subject? Okay, well, in that case, we move to the next subject, which is a change of subject, and it's about financial protection, financial security. And those of us in the UK know that the Civil Aviation Authority is proposing to make much stricter, more difficult rules for the industry, which are very controversial and causing a lot of upset at the moment. So I thought it was worth asking our colleagues whether that's a pattern which we're seeing in other European countries as well. So I'm going to ask Jacqueline Tanti-Dougal from Malta to start off and tell us about the Maltese system. I should say that since Brexit, of course, many British tour operators who want to sell packages to other European countries have had to find a country in which to register themselves and comply with their system. So what we're talking about now will also be relevant to those situations. Jackie, over to you.
Okay, so hello everybody. I will be talking about the insolvency fund in the Maltese system, which has been created through legal notice, and obviously now it is a subsidiary legislation. Actually, all the travel agents in Malta who are selling packages must have this insolvency fund to be in line, obviously, with the EU directive. And this insolvency fund, it's quite, what can I say, maybe easy, or it's the board, it is like this, it works like this, that there is a fund which is created by, let's say, the government, because there is a board on it. There is a board which has been created through this subsidiary legislation. And this board, there are 5 appointed people on it, 2 from the travel agents. 1 is appointed by the Ministry for Tourism. And there are 2 members from the authority. So you have a board which is managing this fund, which is being created so that in the case of insolvency of a travel agent, then it will step in order to compensate or to provide what is needed to the consumer. Now, all the travel agents, obviously, who are selling packages must be licensed and also must be in line with this insolvency fund. Their contribution is that each travel agent would have a 10,000 euro bond. So it is a 10,000 euros. However, what even Clara pointed out, which I was not even, realized that this is an interesting point, is that all the travel agents who are selling packages must contribute 2 euros for each travel package that is being sold. Obviously, for persons who are over 18 years, and this does not apply for businesses, for business persons, in line with the travel package as well. And the 2 euro fund is then, the 2 euros is then contributed also to the fund. What happens is that each, for these 2 euros that the travel agent is contributing to the fund, a certificate is given to the person who is traveling, the traveler. And this certificate is that it represents that they have paid, the travel agent has paid the contribution towards the insolvency fund. Should there be an insolvency, obviously, the person who has this certificate would then go to the fund in order to have the money paid, if there is any money which he has paid for the package, or else, for example, if he cannot continue on the package. So that is how it works, this insolvency fund, in a very in a nutshell, because I cannot stay being all the details in it. But what is interesting is that obviously it is there in the law, the 409.19, for whosoever is interested. All he needs to do is the insolvency fund, and it will come up. And also there are terms of reference which are attached to this insolvency fund, which are obviously not the law, but they help in the proceedings of the board. And there are a lot to say, but that is what I wanted to say about this insolvency fund, in the sense that what Clara pointed out, what is interesting is that this is a computer-generated 2 euro that is being contributed directly to the fund, plus the 10,000 euros from each travel agent.
Thank you. And is there any sign of the authorities in Malta making it more difficult for travel agents or tour operators?
Well, it means now they have increased maybe to 20,000 as well in certain circumstances. However, if you don't mind, there is a David Mifsud on this also with me here, and he's doing actually a thesis on insolvency fund, and he also works with the Malta Tourism Authority, because he's going to become a lawyer as well pretty soon. So I don't know, maybe David would like to intervene if he's here.
Yeah, David, very welcome to say a few words.
Hi everyone. So yes, it's David Mifsud. I work with the Tourism Authority, and just to add on to what Jacqueline is saying, basically there are no particular intentions of making it definitely more difficult for travel agents to participate in this insolvency fund. Actually, initially, we already had some controversies about the flat rate of 10,000 euro. In fact, the smaller agencies were seeing it too much for them, and they said the flat rate is not fair for everyone. Having said that, as Jacqueline said, yes, there are instances where, because obviously the law allows and the terms of reference allowed, where there are particular instances where increased risks are identified, then in each particular case, the board has the right to request additional securities in this regard. So that could be, apart from the bond, requesting, for example, a further bank guarantee, which covers the extra risk which that particular travel agency would be obviously putting the fund at risk. So in a nutshell, yes, that is the position of the insolvency fund at this stage. I mean, there are much other details I can add on about how it functions, because I'm pretty on the ball at the moment, but I think this was the question that you, Stephen Mason, was asking.
Thank you, David. Yes, I may come back to you later if that's all right. But thank you. Thank you for the moment. Klaus, what's happening in Germany? You've had a bit of a revision of the system for financial protection, have you not? Klaus, you're on mute.
So for German tour operators, let's say it's easygoing with a newly implemented DRSF, which is a fund system where you have to pay a certain amount of annual fee, which is 1 to 1.25% on each booking. That is a one, and then you have to pay a counter guarantee on top. So that is workable, but very, very, very expensive to all the tour operators. One of the reasons why certain bigger tour operator groups try to go off, but it's a obligatory fund for every tour operator with a revenue above 10 million euros in package travel. So it's not that easy to switch it off and to went away to another. But for example, as Jacqueline told us, Malta is less expensive, and I can tell you Cyprus is also very much less expensive, and there are options. If you go for a registration in that country, you can reach that situation that you have a bonding in Malta or in Cyprus, and then use it within the mutual recognition, which is allowed by the package travel directive. And with the mutual recognition in each other 26 community states, you can work and you can offer your tours in all European countries. We still have gray zone offers on the German market as well as on European markets, which is, for example, the IPP solution. Some tour operators do with that IPP a pan-European solution since 2 or 3 years. And they are not affected. Some of them are affected on the German market due to the fact that the TUI himself is questioning the validity of that IPP system. To make it to a funny story, TUI Belgium, for example, is by themselves using the IPP for their insolvency bonding. And in Germany, the same TUI is requesting whether that is a valid one or not. So it's a bit a crazy situation, but all in all, it works for, let's say, German or German registered tour operators. When it comes to non-EU tour operators, so let's say such based in Switzerland or such based in the UK, we have huge problems to bring them into an insurance situation or into the Force system. It is quite critical to reach an agreement with the DRSF on the one side or with an insurance that is willing to do a bonding for UK entities. So for me, in the near future, the only option will be a CAA, and APNA and the UK authorities getting into a bilateral agreement with the EU Commission again, which is then the same mutual recognition as we have between all other EU community states to make a level playing field. So far, it's quite difficult for UK operators as well as for Swiss operators to do that job on the same level as the German or the other EU community states operators. For the package travel, that is the situation. And then we have on top of that a heavy discussion. Why do we discuss that just for package? Because during the pandemics, we had millions and millions of customers having booked a flight and not getting their money back. For example, in Germany, Lufthansa has received 9 billion from the government and did not repay in time, means within 14 days or a similar period, the tickets of their customers. So that is a situation where customers even wait 6, 9, 12 months for their money or even longer. And that is the reason why the German Consumer Association actually has developed a draft saying we need an insolvency for airline tickets as well. And that is actually discussed within the German government. So I expect more or less within a year that we will have also insolvency insurance that is done for all kind of airline tickets.
Wow, that's really interesting. Thank you very much. In the UK, there's been talk about financial security, financial protection and airlines for years, and nothing, and reports get written and promises get made, but nothing ever seems to happen on that subject, which is very frustrating for the tour operators and the travel industry. And also talking about financial protection for packages, as I mentioned, first of all, we have a very complicated system in the UK because there is a different system if there is a flight included in the package, and a different system if there is no flight included in the package. But most foreign packages include a flight, so they're controlled. Financial protection is controlled by the Civil Aviation Authority through the ATOL scheme, and one of their proposals, there are a couple of major proposals. One is to make the, Jacqueline was talking about the €2 per passenger. Well, we have the £2.50 per passenger charge, which goes into the fund, the financial protection fund called the Air Travel Trust. But one of the proposals is to make that flexible so that it might be higher or lower depending on the price of the package or depending on the situation of the package organizer, how financially sound they are, which doesn't seem very fair on the consumer. The other proposal is even more controversial, though, and it's the one about segregation of funds, that when a tour operator takes money from a consumer, there are very strict rules as to what it can use that money for. And there is no decision yet. There's a consultation going on, but there's no decision yet as to whether that could be the very extreme version where you cannot lay your fingers on a penny of that money until the holiday has taken place, or a more flexible version that allows you to pay suppliers out of that money for that package. We don't know. But there is a lot of unhappiness in the UK about this, and a lot of puzzlement as to why it's necessary in the UK to make this much more difficult and to impose these rules, which will have a major impact on the cash flow of tour operators, which has already suffered badly because of the pandemic, whilst similar measures don't seem to be necessary in other European countries. So any comment from anyone on anything we've heard so far?
May I interject? Stephen is Barrett here from ASO.
Yes.
Can I ask the esteemed panel? We all talk about financial protection amongst ourselves, with the lawyers, with the regulators. It's only now there's been a sea change slightly in the consumers, it might be temporary, that they're looking at financial protection as an important element of booking a holiday. Can I ask our European partners what the consumer views are over there on financial protection? Are they bothered, or do they just trust the company they're booking with? We'll go with Klaus first, because he's always quite vocal on these matters. So, Klaus, what's it like in Germany? Does the German consumer, are they bothered by financial protection, or do they just book with their favorite company and that's the end of it?
No, honestly, there are a lot of gray zones. So yes, due to the media and to the publication, and then due to the Thomas Cook story, people are very much interested in having a package travel that is bonded. But they also know that what is said on the small sheet of paper by the EU is not true. So in case there will be 1, 2, 3 insolvencies in the same year, that the level of funding and the level of bonding might not reach to get a full payback of their travel fare. So they are questioning a bit about the level of bonding, and they are in a way more discussing what happens to me if I do not have a package. But if I have linked travel arrangements, if I have an airline ticket by myself and book just the land program with another operator. So they are a little bit confused about the new package travel directive and the different travel modes and the different levels of protection. That is one part why we come to that, I think, a little bit later. The EU Commission is still discussing about having a same level of protection to all kind of travel modes.
Thank you. Anybody else want to have a go at Bharat's question? No, they've all gone very shy, Bharat.
In European markets, then, does payment by credit card have an impact on who carries the liability in case of insolvency? Because over here, the booking conditions say, if this man goes bust, this company will pick up the tab. But when you call that company up and if you pay it by credit card, they'll say, go talk to your bank. Is that the same in the EU? They're all very quiet, Stephen.
Yeah, all very quiet.
Who
Sarah's gonna
starts?
come
No,
in.
I can add slightly to that. So yeah, it's a horror. Honestly, a credit card and insolvency doesn't fit, and the cashback system that gives the option for the consumer to get his money back at an early stage, because the terms and conditions of the service providers and the card providers are so confused in terms and not related to travel at all, which makes I had a lot of cases where the consumer got his money back twice, the travel agent has nothing, and the airline in between has just repaid the normal travel fare. But in the end, it is getting a lot of money back to the consumer, which didn't belong over there. And no one is discussing really the interim step with the insolvency bonding, because everyone said, do first your cash back with your credit card and then go to the insolvency bonding system. That is a bit different in Germany, but in the end, that credit card system are not working with the legal routines that we have implemented for the travel contract. So that goes not very properly in the correct direction. So at the end of the cases, it's always one that has too much money.
Yeah, I see. Does Clara want to add to that?
Maybe I would add that we were analyzing cashback system for several tour operators during COVID, because they were basically asking us, can we do something to stop cashback? because when there's cashback, it's not under their influence, which they didn't like. We really spent quite substantial time analyzing the cashback system, which Klaus as mentioned is terrible. Of course, we couldn't go through all the US-based Visa, MasterCard codes, which are real codes, but written in the common law system, not the way we are used to here in Europe. But definitely what we found out that for tour operators or our advice after our research was that tour operators should definitely invest into explaining to their banks what were the real circumstances behind the cancellation and behind the requests. Because the banks do or should do the assessment of the claim for the cashback, but as Klaus said, they know nothing about it. They know nothing about tourism. So we were advising the tour operators to provide their banks with the information to basically give them the weapon to reject the claims. And I have to say that in several situations, then we got a feedback that it happened, and the banks really didn't give the cash back. So at the end, they were quite happy.
The most important two words were should do.
Yeah.
Thank you, Clara.
The original question, also we've talked about cashback now, which my colleague Christine, who's on the call, did a huge amount of chargeback, as we call them here, work on behalf of tour operators to try and stop chargebacks happening. But as far as the original point about whether credit card companies or the insolvency fund should be the place where the consumer goes first to claim a refund if the tour operator goes bust. I don't think there is any easy answer to that, but there is a tendency, certainly in the UK, to require consumers to go to their credit card company first before they go to the insolvency fund. It causes tension in all sorts of places. Right, okay, well, very shortly we will be talking about the reform of package travel law, which is a very important subject. But just before we get there, Jacqueline, I think you're going to tell us about some interesting cases that have been decided in your consumer claims tribunal.
Yes. So actually, I want to stipulate that the Consumer Claims Tribunal is only up to 5,000 euros. The jurisdiction is only up to 5,000 euros. And then that is why a lot of package travel comes under this jurisdiction. Obviously, if you want to appeal a decision of the Consumer Claims Tribunal, you need to go to court. Now, if the claim is up to 1,200, then you only can appeal on points of law, but if it's more than 1,200 euros, then you can claim also on points of law and on points of fact. So another interesting thing about the Consumer Claims Tribunal is that one can claim moral damages. The moral damages are up to 500 euros. However, it is to be stated that the Consumer Claims Tribunal can only give moral damages if the consumer would actually ask for them. So if the consumer does not write down that he wants moral damages for ruined holidays, then obviously the tribunal won't give any money back on moral damages. So this is a Consumer Claims Tribunal, is where the consumer goes and he can have a lawyer or a legal procurator to help him. However, if a lawyer goes to help him and he wins the case, the lawyer would need to be paid by the same consumer. It depends who is doing the case. So the lawyer is not going to be paid by the other side, whether he wins or loses. So it is the consumer who would need to pay the lawyer. This means that usually lawyers do not go to Consumer Claims Tribunal for the obvious reason that they will be very small claims. What I have interesting is that before you were saying about the cancellation of the trip, and there is a case where actually this is a case where I say a case, it means also that there will be one person who will be filing the case, but then not only him, but another four people would also file the same case because they will be a group. And so the travel agent would not, if he loses the case, he would need to pay quite a substantial sum. So it is up to the travel agent to see that he wins the case. Otherwise, he would need to fork out quite a lot of money. And now this one is an interesting case because this was a road trip. And so they needed to go from Malta to Sicily by boat, and then from Sicily to Tunisia by boat as well. What happened was that the travel agent failed to book the actual trip from Malta to Sicily. And it was one of the plaintiffs who actually bought the ticket from Malta to Sicily. This was the case where it was on the 9th March 2020. So over here we know that 2020 was the day that actually COVID started even in Italy, and they knew that there was COVID, so you know they were still between two on whether to go or not. So what actually happened was that once they went from Malta to Sicily, in Sicily they decided that they should not go forward to Tunisia to continue the package travel. Now the question was, did they have the right to cancel at this very moment? Now, we are not saying here 2 weeks, like you said before, but exactly before they started the trip. Obviously, the plaintiffs, the law of package travel says that you can, at least under Maltese law as well, this is that the traveler could terminate the package travel contract at any time before the start of the package, Whereas the defendant was saying that, listen, the package did not happen. They did not go to Tunisia, from Sicily to Tunisia, because of unavoidable and extraordinary circumstances because of COVID. So how did the tribunal decide on this? Did the package actually start, or they had a right to cancel this package? And you know, the plaintiff said that they did not commence the package. In fact, even the guide was waiting for them in Tunisia. He didn't come to Sicily. They knew about the COVID situation, and everybody knew it. And so the tribunal said that the package travel did not actually start. Even at that moment in time, it did not actually start because they did not start the trip to go to Tunisia. And since the plaintiff bought the ticket from Malta to Sicily, then it was not the defendant, the travel agent, who actually bought that ticket. And so the travel agent had to pay all the money that was given to him for this tour. And so here the plaintiff actually won the case. So before you were saying that this was, you know, when is the commencement, when can one cancel? And I'm telling you that in Malta, we can actually cancel at the last moment in time. Another interesting case is about, you know, the visa. So you know that the travel agent must inform you that you need a visa to go abroad if you need a visa. And this one was that they went a cruise, and they were a couple, and the wife was Chinese. And this cruise had to pass from Belgium and then go to England. Now the Chinese need a visa, and to even us is envisaged, I think. So the Chinese lady needed a visa to enter the UK, and but one of the the people at the travel agency told them that, listen, you can still travel on this cruise, but you know, you don't go down in England. Don't go down in England. So they went to actually to get the ship, not from Malta, from another European state, and the cruise told them, listen, you cannot come on this cruise ship because you cannot go to England without your visa. But however, they said, no, but we can stay on the ship during the time that the ship is in the UK, but we don't go down. But obviously they said, no, you have to go down the ship. And so you have to disembark, and then you embark again on the following days when the ship is not in England. And obviously when they came back, that's what they did. They disembarked for 2 days, and they got all the receipts. They presented a case in the Consumer Claims Tribunal, and they said, listen, we were informed that without a visa we can still go on the cruise and we're not going down. But when we went, obviously they told us that we could not go on this particular 2 days when the ship is in England. Well, how did the court, the tribunal, decide? The tribunal noted that you know, it was also the fault of the Chinese lady for not getting a visa, because she knew that she requested a visa, but she did not actually go all the procedure all the way to get this visa. But obviously it was also the fault of the travel agent because they misguided them. They gave them wrong information. And so what happened was, in this case, the tribunal decided that 1/3 should only be paid. The tribunal awarded from 1,000 euros that they requested only 318 euros. So here we see that the travel agent did not pay for all the expenses, but given the fact that the consumer knew that they should not go to England without a visa, it was like contributory negligence from their part. This is also another case with regard to a visa, and also the court noted that the consumer went to Alaska, and obviously he could not go forward in this cruise. It's another case. And here even the court said that the fact that the consumer did not know that Alaska was in the USA meant that even he was negligent on his part. So the travel agent should not pay for the stupidity of the consumer. And in this case also, from 12,563 claim, 1/3 had to be paid, borne by the plaintiff, and the rest obviously by the travel agent. This Consumer Claims Tribunal follows also the principles found in the package travel directive. However, sometimes the package travel, the claims are rather ridiculous, sometimes just for 47 euros. And even the Consumer Claims Tribunal says, listen, this is too petty, so, you know, I don't give you anything. But before I said also that about the moral damages, what I want to say is that if the consumer does not know how to write the claim, okay, and there was a case where it was a ruined holiday for them because they went on a cruise, and when I say cruise, this is a package travel because you need to get a plane and then you need the cruise, just the cruise. But the cruise was horribly, it went a bit wrong because even there were not things working, etc., etc. And the lady who wanted to make a claim against the travel agent claimed 6,000 euros. However, the tribunal noted that she claimed 6,000 euros as moral damages, not as damages. So for moral damages, obviously, the court said, listen, I cannot give you 6,000 euros damages. I can only give you up to 500. So I'll be giving you 450 euros. And the rest of the claim was thrown out. Also in this case, since she did not file the case with her husband, but only she was sorry, only she filed the case, it meant that the husband, who was with her on the honeymoon, obviously, could not get a cent because he did not appear also in this in the claim. So as we are seeing here, the Consumer Claims Tribunal is very specific, and also if the claim is incorrect, obviously they will also throw it out. Thank you.
Thank you very much, Jackie. A fascinating insight into the claims that come forward and how they're dealt with. I think many of the audience will like the idea of a €500, or we'll even say £500 limit on general damages for disappointment, loss of enjoyment, etc., etc. I think we could all be very much in favour of that rule in our different countries. Right. Okay. Well, thank you very much for that. Let's move on to the review of the Package Travel Directive and the Package Travel Regulations, and also we'll say a few words about possible review of the Denied Boarding Regulation, EC 261/2004. But to start us off on this subject, what is happening? Clara and Renata, I think, are leading us on this subject. Thank you.
Stephen, thank you, but I think I've talked enough, so I will this time give the floor completely to Renata, because and why to Renata? Because Renata, she has been working for Czech government for many years, and actually when the previous where the actual package travel directive was drafted in EU a couple of years ago, she was involved. She was representing the Czech Republic at the how is it called? Working unit or
Working group
of
the council.
So that's why I ask her for the insight, so that we all can know from the intruder how possibly it can be how the new package travel directive and its changes are probably going to be elaborated, and I think then she can give us some ideas of how long it's going to be. And the question is also whether maybe we lawyers or the association of travel lawyers can affect the preparation of the revisions. What do you think?
Thank you, Clara. Renata.
Yes, Clara, indeed. You can affect the negotiations. Maybe I will start from the end. When we started to negotiate the previous PTD, the Commission brought the initiative in July 2013. And as all you know, PTD was published in the official journal in December 2015, which is 2.5 years of negotiations. And as you lawyers can contribute to negotiations, you can now communicate with the Commission and with the Presidency your views, because Commission launched many public consultations, but you can send them your views and suggest that you are willing to come and present your views within workshops. Because when starting to negotiate the draft of legislation, it starts with the Commission that brings the initiative, and then it goes to the Council and to the Parliament. To the Council, it goes to its lowest level first, which is called the working group. This is where I was participating. And then it goes to the other levels of the ambassadors, its COREPER, and to the ministers. But to start with, the best is to bring your views to workshops if they will be willing to organize them in Brussels. I recommend it, actually. But to make the long story short, what we can expect that the Commission will come up with something by June this year. They promised to publish either the legislative initiative, or they will come up with some non-legislative measures. What they are doing now in the Commission is the impact assessment report on different scenarios regarding different questions. What these questions are: first, they might regulate rules on voluntary vouchers and clarification of additional rules on refunds. This is all we know, the recommendation of the Commission from May 2020. So they most probably, they will think about including some stipulation on the vouchers, that the vouchers must be voluntary for the consumer and they must be protected against bankruptcy. Secondly, they might bring some new rules on national insolvency protection schemes. Thirdly, they might think, or they are now evaluating potential creation of a special fund at union or national levels to cover refunds in times of crisis. So not only they are talking about insolvent bankruptcies, but they are now talking about the crisis, whether to create the fund to cover these crises on national or union level. They are also thinking about a possible limitation of prepayments. And it was mentioned already here by Klaus. They are thinking of imposing insolvency protection on airlines and new rules for providers of travel services. Actually, this is a very sensitive question because the European airlines are already in difficult situation, because you all know the rules on subsidies in the EU. And you all know that the situation on this market is difficult because the European airlines must compete, for example, with the airlines from the Gulf states. And there is maybe no certainty that subsidy rules work the same on the side of these states, maybe. And moreover, the airlines are now regulated quite heavily. In order to get the license for airlines, you have to comply with very strict rules. So I'm just saying that this is a sensitive question. It's being now discussed within the Commission, and we will see in June what they will come up with, whether it will be a legislative or non-legislative measure. Last but not least, possible alternatives to the current rules on linked travel arrangements. They will come up with this as well, and I would like to place the question: who out of all the lawyers that are here now, did you have cases regarding linked travel arrangements actually? And as I said, after the Commission, if the Commission will publish its legislative initiative by June, it will not be before, I doubt it. Then it goes to the Council. As I said, first they read it in the working group, and it goes at the same time to the European Parliament, and there it will be IMCO, this a consumer protection committee, and TRAN, which is the Committee for Transportation and Tourism. Those two committees are very important. Maybe you can send your views even to those two committees as well. And both institutions they will try to reach the agreement on the text, and the draft of law, the piece of legislation will be passed to first and second readings until they reach conclusions between the institutions, and then it's published. So I hope I took my time and I was not long.
No, thank you. That was very clear summary. Thank you very much, Renata. I was wondering, I think everyone agrees that linked travel arrangements have been a bit of a failure, and it comes through from the papers the commissioners already published on this subject. Do you think the answer is either that they will become packages, or that they just have no purpose at all and they should be just abolished completely?
I would say they would rather go to a solution that maybe these individual travel services can be covered by insolvency schemes. I don't know if they would delete it completely. It's as you said, it's a rather failure. And it was actually, it is in the PTD because of the airlines, I would say so, but not only because of the airlines, because the consumers may lose a lot of money even for paying the accommodation. So it's not only the airlines. I think they will reduce the provisions that are related to linked travel arrangements.
Thank you very much. About airlines coming within the financial protection scheme, you said it's a very controversial subject. Do you think sensitive? All right, a very sensitive subject. Do you think it will happen?
I don't want to predict this because it's been for many years, and if I'm not mistaken, the draft of amendment of regulation 261 has been placed in 2013, which is 10 years by now, and they were not able to agree on any further progress, or I don't think there is a progress.
Well, Klaus is going to say a few words about 261.
I will leave it to Klaus
in a few minutes, but okay, well, thank you very much for that great summary. We'll see if you are asked any questions, but first of all, Klaus, could you come in and say something about the reform of 261? As Renata was saying, it's been talked about for a very long time. When the UK was part of the EU, the excuse for the lack of progress was the dispute over Gibraltar Airport between the UK and Spain. However, now that we're not in the EU anymore, presumably that problem has gone away and shouldn't prevent progress. So is anything happening on a reform of EC 261?
At least the same story that Renata mentioned so far, that there are working groups running, and that working groups try to answer a 50-page questionnaire in order to find out where we do have problems and where there need to be an improvement that is really necessary from the perspective of the EU Commission. And beside of that, all the airline guys and lobbyists are working strictly against it. So what is definitely under discussion is to have a percentage of the ticket price, as we have it with trains as well, that in case of delay, you have 15, 20, 25% of your ticket price that is the compensation or penalty payment the airline has to take, instead of the actual fixed amounts of 250, 400 and 600 euro, depending on the length of the flight. So that is an intention, of course, basically of the airlines, but the EU Commission is also joining that argument, saying that it is probably not fair with ticket prices of 29 euros per leg to have a 250 payback in terms of delay or cancellation or whatever. So there are some areas that are moving forward, and what is also under discussion, which comes more with a discussion around the package travel directive than to the 261/04, is a question that we had before with insolvency bonding also for airline tickets. So that is to create a level playing field, which is always an argument for the EU Commission, to have that in line throughout all community states. I doubt whether that will happen, but we will see. So yes, agree, it is 10 years old. It took a long time for a lot of discussions to get an improvement or a review of that directive. But I do believe that with the pandemics, there are a lot of things moving forward. I'm not sure whether they are moving in the right direction, but still they are moving.
Thank you very much, Klaus. And David, you've got your hand up, so please come in.
Yes, just more like a question and a comment at the same time regarding linked travel arrangements. During the negotiations way back in 2013, I was representing my country, and I just want to put it maybe a bit diplomatically, that the Commission was strongly informed that linked travel arrangements are a complicated matter, especially when it comes to controlling and monitoring such operations. What I would like to put on the floor, maybe very briefly, is two things. I mean, initially, I see two possible solutions, as were mentioned. One is either going to abolishing completely linked travel arrangements, but that obviously has the downside that a number of travel operators will start using this loophole to avoid packages again, or alternatively, to actually have insolvency protection, as was mentioned, for individual tourism services. However, it is not as simplistic as one might see it to be, because what actually constitutes a tourism service? What I say, for example, the tourism authority does not, for example, license car hire, which is anyway part of a package. Accommodation can be done directly with the hotel. So would it be done, if it's done through an agency, it has to be protected against insolvency, but if you book directly with the hotel, then you don't need insolvency protection. Then obviously travel operators will start complaining that they are at a disadvantage. So the solution is not simplistic. I don't know if some others have some other ideas on what might be pushed forward on the Commission's agenda in this respect.
Thank you. That's very helpful in addition to our discussion. Thank you very much, David. So we are coming towards the end of this event. However, with time for one or two observations or questions from the audience, if anyone has anything they'd like to raise.
Maybe I would add something to what David said before regarding the protection of individual travel services. I think the consumers, they should think before they buy a service. And if the law makes sure that they receive the information, this service is protected against bankruptcy, this is not. Why do we have to always lead the consumer and tell him that he must always buy the protected products? Leave it up to the consumer to decide, maybe in those cases. So I think that consumers, they need information, but they have to make the qualified decisions themselves.
So, for example, if you were buying a hotel, there'd be two prices, would there? A cheaper price which doesn't have financial protection, and a more expensive price that does have financial protection.
Yes.
And the consumer can choose. Yeah, okay, thank you. Anyone else that wants to make a contribution on this subject or ask a question?
I have a question, Stephen. Is there any idea from anyone how many LTAs are actually sold over the course of a 12-month period?
I'm sure the answer to that is no. I'm sure the answer to that is no. But
I think
so. We're protecting something we have no idea about scale, volume, other than the airlines don't want it, which is normal.
I don't know what's the situation in other countries, but in the Czech Republic, out of 800 something tour operators, there are maybe 10 of them that have a license for linked travel arrangements.
At least you have a licensing scheme for it. Over here, I think it just carries on under the table, as it were.
Yes, I think you're right, Barra. And it's not deliberately. quite often not deliberately so.
No.
People don't realize that they are facilitating or selling, whichever you prefer, a linked travel arrangement. Okay, well, thank you.
I like Renata's idea about consumer making the choice, but as we've seen with Monarch and Thomas Cook, when push comes to shove, our government repatriates everyone.
Yeah, well, that's true. Okay, well, thank you. The one remaining subject on our agenda, I will deal with very quickly indeed. The right of redress from suppliers. We talked about this at last year's event, and you will recall that the directive says that where a tour operator has to pay compensation or give a price reduction, etc., under package travel laws, member states shall ensure that the organizer has the right to seek redress from any third parties which contributed to the event triggering the compensation or the price reduction. And many tour operators thought that airlines were responsible for massive alterations, cancellations, etc., which resulted in the tour operators having to make refunds to consumers under the package travel regime, but which they were not able to get the money back from the airline in turn. And I think I said last year, there are two very large claims going on against Ryanair in the UK jurisdiction, with tour operators making big claims against Ryanair. And among other things, among other categories of claim, they're claiming under that provision. And the cases have moved forward, but they're big cases, and so they move quite slowly. And so I'm not able to tell you the result of those cases yet. Let's hope for the package travel industry that the cases go in favour of the package travel companies in those cases. So with deference to the time, I will say that that is the end of today's event. Can I just very quickly remind the members of the International Travel Law Network to stay on the line, please, because there's something we're just going to discuss between ourselves very, very briefly. But for everybody else, I'm so grateful to you all for attending in such large numbers and from all over Europe. Thank you very much. I personally think there's been unique content this afternoon that you'd find it hard to get anywhere else. I hope you found it worthwhile, and thank you very much for attending. So if the audience would like to leave the call now, and thank you very much.